We're starting off with impeachment, and where I wanted to begin is by taking a look at where we can get some guidance on how this is all going to work. And a very good resource is called the Congressional Research Service. So what I want to do is I want to show you some resources that exist. We can identify when they came out, see how relevant they are. Then I'm just going to show you that even according to them, there's not a lot of rhyme or reason about how this is all going to unfold. The rules are sort of made up on the fly. They're subject to a lot of change, and so it's a little bit of a free-for-all in the upcoming days and potentially weeks. So let's take a look at where you can find some of these resources. This is from the Congressional Research Service. If you go over there and you type in the word impeachment, you're going to see a lot of different documents will come up. So some of the more pertinent ones I have boxed and outlined in red. And I've looked through some of them, not all of them here. I've really kind of gone through some of these, the three that are in boxes. Number one, the impeachment investigations, the law and the process. But this was written back in 2019, October 2019. Two other documents were written this year basically in preparation for the upcoming impeachment of the former president. They have this article written by Jared Cole and Todd Garvey entitled The Impeachment and Trial of a Former President. And if you read through that, you'll see that it's mostly talking about, whether or not you can do that. It's a lot of analysis about, how is this proceeding constitutional? It goes through a lot of the history, talking about impeachments of former senators and some other articles of impeachment that were filed around the Nixon era and things like that. And so it was sort of, I think it's really relevant. So if you want to read it, it's not a bad read, but it's kind of discussing something that we already know is going to happen. We know the impeachment has happened, and we know that the trial is coming this week. It starts tomorrow. So some of that, I think, was discussing about whether or not this threshold issue was going to be met, whether this trial can go forward, and it's going forward. So sort of relevant, but sort of less relevant now that we know that it is in fact going. So the document that I think has the most relevancy for us is this one that says the impeachment process in the Senate. And I want to just show you this. Again, this is a big long article, but it's kind of a mess. They're also trying to figure out how all of this works. And so I clipped out just a little bit of this before we get into the actual memorandum from Donald Trump. This is what they're telling us. This comes over from the Congressional Research Service. You can see this was published not too long ago, like, what is that? 10 days ago, 11 days ago, on January 27th, written by Elizabeth Rybicki and Michael Green, both analysts with Congress and the legislative process. And here's what they say. The impeachment process in the Senate. After the House impeaches a federal officer, which they have done, arguably, I mean, he was a federal officer at the time. He's not a federal officer now. We're talking about Donald Trump, of course. The Senate will then conduct a trial to determine if the individual should be removed from office, but he's already removed from office, right? This was written, again, on January 27th of this year. The Senate has a set of rules specific to the conduct of an impeachment trial, most of which originated in the early 19th century, so a long time ago. The impeachment rules lay out specific steps that the Senate takes to organize for a trial. House managers, members of the House who present the case against the impeached officer, and we've already identified who those people are, they read the articles of impeachment on the Senate floor. The presiding officer and the senators then take an oath to do impartial justice. It's all been done. This has already been done. The Senate then issues a summons to the accused and then requests a written answer be filed. And that's what we're going to go through right now. We're going to go through this written answer that is filed. It's a memorandum from Trump's team. The House managers are also invited to respond, and we have that as well. So Trump responds. So Trump issues a response, and then they reply to the response. And so we're going to go through both of those today. Actions after these organizing steps, however, are not specified in the impeachment rules. And this is where things get a little bit muddy. The impeachment rules mention some actions that are common in judicial trials, like a criminal trial, such as opening and closing statements by the parties to the case. They also talk about examination of witnesses, although I think that is up in the air. I'm not sure we're going to see any witnesses in this impeachment proceeding based on what I've read thus far, but they provide little specific guidance. Right? Well, it's not much there. Instead, the rules allow the Senate, when setting for a trial, to set particular procedures through the approval of, quote, orders. Some orders of the Senate are unanimous consent agreements, but others are proposals that are adopted by the Senate. If such a proposal is considered while the Senate is sitting for the trial, like right in the middle of trial, then which is starting tomorrow, so it's going to happen, then the debate by the parties to the case, the House manager and the counsel for the accused, is limited to 1 hour for each side. So if something pops up in the middle of the trial, they'll break, they get 1 hour each. As a result, the support of the 3/5 of the Senate to invoke cloture is not necessary to reach a vote of the approved procedure. Such proposals are subject to the amendment, which is also debated by the parties for 1 hour on each side. And if you read the rest of the document, it's kind of following in the same vein. It's a lot of this, well, they can kind of do what they want. They can kind of manipulate things, pass rules, pass amendments, break out for sort of secretive proceedings where they're debating behind closed doors. And so it's kind of anybody's guess, I think. I think the parties who are a part to the lawsuit, parties to this, I'm going to say lawsuit, but it's an impeachment proceeding, right? It's not an actual lawsuit. It's an indictment that came over from the House of Representatives. It's sort of a political indictment. There's not really anything analogous to this in criminal law other than a regular criminal indictment. And so all of this is sort of being negotiated and hashed out right now. I just read a statement from Donald Trump's defense team saying that they've reached an agreement. So I don't even know what that agreement looks like, but apparently they're happy with it. The Democrats are happy with it. And so there are a lot of questions up in the air. Are there going to be witnesses? I'm reading a lot that both sides are going to be presenting videos. I think the Democrats are presenting some videos, probably a compilation of Trump's statements. I read that Riskin, who I think is the lead House impeachment manager, worked with some external firm that's going to be consolidating a lot of the videos and statements from Trump and Rudy and his sons and all of those different individuals. And they're going to lump them into this compilation, play that in front of the senators, and then that's going to be their claim, right? And Trump is going to probably be trying to do the same thing, according to his attorneys. He wants to go out there and find statements from Chuck Schumer, from Maxine Waters, from Ayanna Pressley, from other people in the government and say, look, they use the same type of language that we do, and see how that works out. Now, there's a whole different question here. The judge is a Democrat. It's Patrick Leahy, I think from Vermont. I could be mistaken about that, but he's a Democrat. He's been a lifelong Democrat. Many people say he's impartial, but he's a Democrat. He's going to vote to convict Donald Trump, and he's going to be presiding over this whole thing, even though the Constitution technically says that it should be the Chief Justice, John Roberts, who has refused to come over and officiate this impeachment proceeding. So the next question then, now that you have a Democratic individual who is going to vote to convict the former president, is going to be governing what evidence can come into court, what evidence can't come into court. So is Donald Trump even going to be able to present certain evidence? If he wants to come and play some videos of Maxine Waters, maybe Leahy says, well, that's not relevant. I don't think that's relevant. We're not here talking about Maxine Waters. We're here talking about you, sir. And I think that they would have a good argument for that. They would be able to say, all right, well, yeah, I mean, it's just not relevant. Now, Trump's defense would be, of course, well, you're criminalizing me for the type of language that I used. You're indicting me. You're impeaching me over this language about fight like hell or you won't have a country anymore. Well, all of these other government officials used similar or worse language, as we're going to see when we get to Chuck Schumer. So why can't I introduce it? It's very relevant. It's relevant to show that I am using the same language that is typical amongst other government officials when they're being provocative, when they're out there trying to rally for a cause or move a specific issue forward. And so we'll see where that goes. Now, Leahy might have some discretion there, and he might just decide, well, it's not going to let that in. Then what happens? Where does that go? Where do you appeal? The Supreme Court doesn't want to get involved. That's why the Chief Justice is not appearing. So the whole thing is sort of up in the air. We're just going to have to buckle in and see where it takes us. And we're appreciative that you are here and along on the ride. Let's take a look at Donald Trump's defense memorandum. This is the trial memorandum that are being submitted. They were submitted today on February 8th. Here is what it looks like. In re the impeachment of former President Donald Trump, trial memorandum, and it's submitted into the United States Senate, signed off by his two attorneys, Bruce Castor, David Scone, and we have another guy who we'd not seen before, Michael T. Vanderveen, another attorney, all counsel to the president, filed today, February 8th. And what I want to do is go through this. There's a lot here, so there's a lot of reading, but I'm going to try to break it up just a little bit. So we're going to go through the introduction. We're going to look at some of the main bullet points. As I said, this is a 74-page document. Not going to sit here and read the whole thing. We are going to cover what I think are some of the highlights. Now, there are There are a lot of good arguments here. There's a lot of legalese. They go through a lot of history. I actually think this is a pretty good document. Just for completeness, recall we did go through this in the same format with the Democrats' memorandum, with the House managers. We went through that. I think that was probably last week. Went through it with a fine-tooth comb, and also went through Trump's response. We're going to do the same thing again here today. This time we're going to go through Trump's memo. Then we're going to go through the Democrats' response. And so let's keep that in mind. Again, if you want full context, read the full document. It's 74 pages, and I'm not going to spend the entire show reading through it, but we are going to cover the highlights. So let's start with the introduction. This is something that I thought was well done, right? I think that this is persuasive language. It's interesting persuasion in terms of how they're framing this argument, sort of as this hatred for Donald Trump. Introduction. During the past 4 years, Democrat members of the House, they filed at least 9 resolutions to impeach Donald Trump, the 45th president of the United States. And I didn't know that. 9 resolutions, each containing charges more outlandish than the next. One might have been excused for thinking that the Democrats' fevered hatred for citizen Trump and their, quote, Trump derangement syndrome would have broken by now, seeing as he is no longer the president. And yet for the second time in just over a year, the U.S. Senate is preparing to sit as a court of impeachment, but this time over a private citizen who is a former president. So you can see where their argument is going. They're going to be spending a lot of time talking about this private citizen stuff. They're going to be talking a lot about sort of this irrational hatred that the Democrats have against the president, even though he is no longer the president. You see they have that there in italics. He is no longer the president. You're still doing this? In this country, the Constitution, not a political party, not the politicians, reigns supreme. But though this latest article of impeachment now before the Senate, but through this, Democratic politicians seek to carve out a mechanism by which they can silence a political opponent and a minority party. So now we're talking about some due process issues, some abuse of power issues. The Senate must summarily reject this brazen political act. It goes on. And I think I skipped a couple paragraphs here, but this is another good paragraph from the introduction. The intellectual dishonesty and factual vacuity put forth by the House managers in their trial memo only served to further punctuate the point that this impeachment proceeding was never about seeking justice. Same point we've made here. I've talked about this for a long time. You know, if they were really seeking justice, if they really thought he committed a crime, they could indict him for an incitement of insurrection. There are different criminal charges that exist for this stuff. They know at this point in time, if I had to just sort of shoot from the hip on this thing, it's actually not shooting from the hip. There's I think some pretty good data on this, that he's not going to get convicted. Donald Trump is not going to get convicted unless something goes completely awry. A couple weeks ago, if not last week, Rand Paul was out there in front of Congress. He had a point of order in the Senate where he was saying, do you think this is constitutional or not? Something like 44 Republicans said, no, not constitutional. So that is already outside the threshold. Unless some people who voted that way change their votes, the likelihood that Trump actually gets convicted here is basically slim to none. And as we're going to see as this argument unfolds, it's necessary in order to prevent him from running again. They need to convict him in order to prevent him from running again. It's not one or the other. I've heard some other arguments that, well, they don't need to convict him, but they can just preclude him from running again. No, it's one comes after the other. And so if they know that this is a foregone conclusion, if they know that this is not going to go anywhere because 44 Republicans have already indicated as such, saying that this is not constitutional, then what is this about? I mean, truly, what is it about? Is it about justice? Because they're not going to, I don't know what their version of justice is. If they're defining justice as just being, we just kind of left all this stuff out on display, then I guess that's okay. But if justice is the end result, if they're saying that Donald Trump committed an offense against America and America needs to be made whole for his incitement of insurrection, well, he's got to be penalized, right? And that in order to be penalized, he's got to be convicted. So if they can't convict him, they can't penalize him, then are they really adhering to their form of justice? Now, the other argument here is, and this is something that happens a lot in criminal law in our practice, you can have a case where you think that you're going to lose and you still go to trial anyways. It happens all the time. You can basically have no arguments. The facts can be bad against you. You can just presume that your jury is going to go one way. In this case, the jury are the senators. So the Democrats here, they might say, well, we know that currently the senators have said that they are not going to vote in favor of convicting Donald Trump, but they haven't seen the evidence yet. They haven't seen what we've presented, and Donald Trump hasn't hasn't presented anything. And so strange things can happen in trials. So I'm actually a big proponent of going forward with the trial anyways, even if you think you're going to lose. There are times when just weird things happen. Donald Trump might stand up and just start blasting something. His attorneys might say something might happen that causes the senators to react and change their votes, right? I mean, nobody predicted that the Capitol Hill riots would happen on January 6th. They did. I think some people probably predicted that. More and more evidence is looking like a lot of people predicted it, but security, for whatever reason, is what it was. And the point I'm trying to make is things can be fluid. And so just because they're kind of going into it knowing that they're going to lose, or the common knowledge at this point in time is he's not going to get convicted, doesn't mean they shouldn't try. So I can understand that argument. Conversely, at this point in time, I'm thinking Joe Biden said unity, unity, unity. We want to bring the country together. That is obviously not happening. They're trying to move forward with this impeachment. I think that politically, whether you want to agree with this characterization or not, I think that it is an attempt to sort of make Donald Trump supporters, make all of MAGA responsible for the Capitol Hill riots. And I think it's not a fair thing to be doing, but they're wanting to maximize this. They're wanting to get as much political mileage out of this entire debacle that took place on Capitol 6 on the Capitol Hill riots on January 6th. They want to squeeze every ounce of political leverage that they can out of it. Let's go back to the document. Instead, this was only ever a selfish attempt by the Democratic leadership in the House to prey upon the feelings of horror and confusion that fell upon all Americans across the entire political spectrum upon seeing the destruction of the Capitol by a few hundred people. Instead of acting to heal the nation, or at the very least focusing on prosecuting the lawbreakers who stormed the Capitol, the Speaker of the House and her allies have tried to callously harness the chaos of the moment for their own political gain. And yeah, I mean, there's a lot of other things that they could be doing, right? Schools are still closed in many states. I'm not sure that Americans have gotten their stimulus checks that were promised. I think there's still a lot of people that need to be confirmed by the Senate. And so a lot of the Senate business seems like it's kind of on hold in order to make room for this political show trial that we all know really has no chance of being successful because the Republicans have already voted and said that it's not constitutional. So what is it for then if it's not to actually be successful? Well, you can be your own judge of that. All right, so let's dive into some of the facts. Statement of the facts relevant to the article of impeachment. The House managers' compulsion, so this is where they're getting into the argument, and they're saying this is they're kind of clever with their language, which I can appreciate, but I also kind of don't. I like it when it's a little bit more clear in terms of what of the point they're trying to make. So statement of facts relevant to the article of impeachment. And if you read this entire section, section 2, you'll see here that what they're trying to convey is that the Democrats had a lot of fluff in their motion in their memo that really had nothing to do with the allegations here. So let me back up and just frame this out a little bit. So when we're talking about sort of the chain, how you connect the dots from one side to another, you're saying you've got the Capitol Hill damage. And what is that? Well, it's all the physical damage that happened to the building. It's all the sort of symbolic damage. It's the physical trespass of people into the Capitol Hill building. You've also got the inability of the government to function correctly, right? They were trying to go forward and certify the Electoral College. That was thrown off because of that. So that's a harm, that's damage. We know that. We know there's a ton of damage. We know that there's a lot of people arrested. They're still investigating it. They're still, fixing things up. There's still National Guard troops surrounding the certain facilities out in D.C. So we know that. We know all of that. That's horrible. We can all agree that all of that was bad and a gross day for America. But what does that have to do with Donald Trump? This is where they have to make the connection. They have to say that something Donald Trump did was the direct cause of all of that. And so those are pretty important points, right? You can say that there's a big bucket of bad things that happened, but what good is that? You got to figure out where it came from, who's responsible for it, and how did it happen? And so when you talk about negligence in sort of tort law, you talk about a duty, a breach, a cause, and a harm. Okay, so somebody had a duty to do something, they breached that duty, and they were the direct but-for proximate cause of the harm. And so right now, what this is arguing, the second main section in Trump's memo is that they were just fluffing up the harm part of it. Lots of information about that. Lots of stories, news stories, horrible. Everything was a mess. It goes on and on and on. And we read through it here, and it was a lot of that, right? It was a lot of news stories. It was just sort of paragraph after paragraph after paragraph, after story after story after story of a person injured. This was broken. This was stolen. This person was indicted. Media said this. Trump was running around laughing his head off, right? All of that stuff, which is important. It's a key element. You need that, but you also need the other elements. You also need, well, who did it? Who's responsible for it? And what did they do specifically that led to the outcome that we're so disgusted with? And so as we're going to go through here, you're going to see that they're sort of making the same point that it's kind of missing those other two requirements. It's missing the person, the actor, and the cause. So let's go back to it. It says, the House manager's compulsion to obfuscate the truth is born out of an absence of evidence relied upon in their statement of facts. As the body vested with the sole power to impeach, the House serves as the investigator and the prosecutor. But there was no investigation. The House abdicated the responsibility to the media. Of the 170 footnotes in the House manager's trial memorandum, there were only 3 citations to affidavits of 4 law enforcement officers, and they were merely referenced to support descriptions of what rioters were wearing and the weapons that were found. The rest of the purported, quote, facts relied upon by these constitutionally charged prosecutors came from hearsay through the media, right? And that's a pretty important point. You know, this would be like being charged with a crime and not having any evidence of it. Just a bunch of people saying what the damage was for the crime, right? Okay, well, so your house was burglarized. I'm really sorry that happened. Yes, I know they took your lamp. I know they took your jewelry. I know they took the wallet. I know it's horrible. And everybody out there is saying it's horrible. And everybody else is saying that this is bad stuff going on. But what's the evidence about the person who you think did it? Did they do it? Were they actually responsible for that? You got to talk about those things. And here they're saying there's 170 footnotes, most of it from the media. We had 3 citations to 4 law enforcement officers. And they weren't providing any actual evidence that Trump was the inciter, that he said anything that contributed to the incitement of the damage. So it's a lot about the damage, but not about the cause of the damage. And then they go on, and this was an important thing that I wanted to just touch on. There's a footnote here, footnote number 8. This is where they're talking about you'll remember this, in Democrats' memorandum, there's a whole section there about after the fact. Okay, Donald Trump, after this was all taking place, he was out there still trying to call senators. He was kind of, giggling around the White House, just sort of, meandering about, gleefully happy that this is all going on because it was going to delay the certification of the election. And he was just thrilled about that, right? And I was thinking, we've kind of heard that. It was like a game of telephone. Went from one person to another person to another person onto the front page of the New York Times. And we're all going, all right, well, that sounds like something you would want to be true. Conversely, you've got the other side saying Trump would never do anything like that, right? That's something that they want to be true, but there's no real evidence about it. It's all hearsay stuff. And it's all people, one person tells another person. It's a game of telephone. Mike Pence didn't come out and say, yeah, I got a phone call from Trump that said, how's that feel, sucker? As he's laughing from the Oval Office, right? There's no real sort of direct witness testimony about this stuff. It's hearsay. And so on footnote number 8, we have an explanation. The House manager's suggestion that President Trump did not act swiftly enough to quell the violence is absolutely not true. Upon hearing the reports of violence, he tweeted, pleading with the crowd to be peaceful, followed by a tweeted video urging people to go home and to do so in peace. And some of this stuff was actually mentioned in the Democrats' memo, and they were unhappy, I think, with how long it took. So there was about a 30-minute window in between some of the tweets, and then another 45-minute window in between some of the tweets. And you can say that took too long, right? He wasn't as active. But again, we weren't there. I don't know if he was being transported yet. I'm not real sure that the country knew exactly the extent of what was going on at the Capitol until it was kind of almost over, right? We were all sort of watching it in shock that this was unfolding right in front of us. And so what they say is he and the White House further took immediate steps to coordinate with authorities to provide whatever was necessary to counteract the rioters. The fact is there are complex procedural elements involved in quelling a riot at the Capitol and on the Mall. They're dealing with the D.C. police, the Capitol Police, the National Guard, etc. There was a flurry of activity inside the White House working to mobilize assets. There is no legitimate proof, nor that can there ever be, that President Trump was, quote, delighted by the events at the Capitol. He, like the rest of the country, was horrified at the violence. And so, I think that interpretation, that recounting of the events is as legitimate as anything I've heard on the other side. And we went through their entire memo. They were saying that there were they were referring through to a lot of news stories and a lot of other articles from sort of the Capitol Hill, aides or whatever, people saying, oh, he's just thrilled and gleeful about this. Well, he's saying I'm not, right? So pick whatever side you want. If you're a Democrat, you're probably in total disbelief. If you're a Republican, you're like, yeah, that sounds about right? There are 3 different agencies. There's a number, not to mention the DOD, the DNI, all of these other people who are involved. So if there's a 30-minute window where he didn't get his phone out and tweet something, I think I can give the guy a break on that. Let's go into some of the next arguments. So the single article of impeachment here is belied by an analysis of Mr. Trump's spoken words to a crowd gathered at Ellipse 4 on January 6th. So what they're saying here with this is essentially, if you actually listen and read and go through what was said at the Save America rally on January 6th, you'll know that the article of impeachment that was drafted just doesn't match up. It's belied by that. Just a simple analysis will show you it's not there. At the demand of the Speaker of the House, certain members of the House drafted and introduced Resolution 24, impeaching Donald Trump. The single article is entitled Incitement of Insurrection, and we've gone through that a lot, about 3 or 4 times here. They charged Mr. Trump with engaging in high crimes and misdemeanors by inciting violence against the government of the United States. Incitement is the act of encouraging someone to do or feel something unpleasant or violent, and they reference you down over to the dictionary at cambridge.org. An insurrection, unlike a riot, is an organized movement acting for the express purpose to overthrow and take possession of the government's powers. And here they're citing a case, Eunice Bros versus Cigna Worldwide. This was from the Southern District of New York in 1993. And they're also referencing some other cases out of the Second Circuit. We have another one from the First Circuit. We have another one from the Eastern District of Pennsylvania, sort of all referencing this concept that an insurrection, unlike a riot, is an organized movement acting for the express purpose to overthrow and take possession of the government's powers. Okay, government's powers, take control of it, and the express purpose to overthrow. And they're citing case law to that. So you can sort of take that definition if you want it or not. And I think that the Democrats are not. Okay, they're going to say that it's a much looser definition. Here, express purpose to overthrow. Did Donald Trump say anything about that? I want you to go down to the Capitol building and overthrow it, and we're going to take this country over. And I'm intending that you go and do that in order to meet those ends. I didn't hear anything about that. Anything about taking possession of the government's powers? No, I didn't hear anything about that either. So according to this definition that's in the Trump document, that standard is not going to be met. But if you follow the Democrat standard, which we've talked about here, it's basically anything. It's basically any type of language that you say that is provocative in any sense. And something happens as a result of it, doesn't even have to be violent. If something happens, if something is off that might rock the government in some direction or another, that's enough, right? It's a very low standard, which is why we started the impeachment part. Because according to their own document, and you can find the article of impeachment that they did pass in the House in the description on this channel. It's in there in the paste bin. You can read it. It's like 4 pages. And it just basically says exactly that, right? It's incitement of insurrection. Well, how did that happen? Well, he said a couple bad things and then something happened. Okay, that's it. All right. So we're going to have fun with that. This is what they were referencing over on Cambridge. The act of encouraging someone to do or feel something unpleasant or violent. Okay, so if you're a Democrat, and that's a good standard. Yeah, that's incitement for you. The act of encouraging someone to do or feel something unpleasant or violent. If that's the standard, yeah, Trump's impeachable. Certainly, he should be convicted, right? Because he said a lot of unpleasant things. A lot of people feel unpleasant things. Same happens to me every time I hear a lot of people speak out there. A lot of politicians. I think that's pretty damn unpleasant. Maybe they should be impeached. Is that the standard that they want to set? It seems to be that way. On January 6th, Mr. Trump addressed a crowd of people who had gathered at the Ellipse, a public land that is part of the President's Park next to the White House. Mr. Trump spoke for approximately 1 hour and 15 minutes. Over the 10,000 words spoken, Trump used the word fight a little more than a handful of times. I think it's a little bit more than that. We're going to go through that here quickly. And each time in the figurative sense that has long been accepted in public discourse when urging people to stand up and use their voices to be heard on matters important to them. It could not be construed to encourage acts of violence. Notably absent from his speech was any reference to or encouragement of an insurrection, a riot, a criminal action, or any acts of physical violence whatsoever. The only reference to force was in taking pride in his administration's creation of the Space Force. Mr. Trump never made any express or implied mentions of weapons, the need for weapons, or anything of the sort. Instead, he called on those gathered to peacefully and patriotically use their voices. And so we went through this before. We have gone through this argument. I'm going to run through this quickly. Donald Trump's speech at the Save America rally on January 6th. You can find the whole transcript over at rev.com. And if you find it and you look up the word fight, if you do a control F and try to find the word fight, you'll see that it's in there 23 times. Right? So they said a handful of times. So why is it 23 times? Well, because the crowd was saying it a lot. So this is from 7 minutes and 11 seconds in. Fight for Trump, fight for Trump, fight for Trump. That's the crowd. Okay. And then when Donald Trump uses it, he says he's talking about Rudy. He says he's got guts. He fights. He fights. And I'll tell you, thank you very much, John. Fantastic job. I watched. So he's talking about other people fighting. Okay. But not going and fighting Congress. He talks about they're out there fighting the House. Guys are fighting, but it's incredible. Jim Jordan, some of those guys. Many of them, I helped get them in. I helped them get elected. I helped Mitch get elected. I can name 24 of them. They're out there fighting the House. He also says, you have to, unbelievable what we have to go through. What we have to go through, and you have to get your people to fight. If they don't fight, we have to primary the hell out of the ones that don't fight. You primary them. We're going to let you know who they are. I can tell you already, frankly. So he's talking about fighting in the context of moving forward politically. And if they don't do that, what's the recourse? That you kill them, that you lynch them, that you hang them, that you drag them out of the chamber in the Congress? No, you don't. He says you primary them. You primary the hell out of them. He goes on. He says fighting like a boxer. Republicans are constantly fighting like a boxer with his hand tied behind his back. So he's using an analogy. We're going to have to fight much harder. Mike Pence is going to have to come through for us. If he doesn't, that'll be a sad day. Okay, so he's talking about fighting in that same context. Political fighting. Everybody had us down for victory. It was going to be great. Now we're out here fighting. I said to somebody, I was going to take a few days to relax after our big electoral victory, but I was going to take a few days. So they're out there fighting, right? They're out there at a rally fighting. He says, now he's talking about the fake news. I'd fight. So I'd fight. They'd fight. I'd fight. Boop, boop. You'd believe me. You'd believe them. Somebody comes out. They had their point of view. I had my point of view, but you'd have an argument. Now what they do is go silent. That's what happens in a communist country. That's what they do. They suppress. You don't fight them anymore unless it's they made a little bad story about me. They'll make it 10 times worse. Talking about fighting with the media. Then he talks about our fight against the big donors, the big media, big tech, and others. Then finally at 1 hour, 11 minutes in, this is where we get to the problematic statement. You got to fight like hell. If you don't fight like hell, we're not going to have a country anymore. This was the total list of the other scary words that he used. There was zero counts of the word riot in there, 0 count of the word storm, seize, coup, nothing about treason, sedition, shooting, raiding, murder, punch, nothing, zeros. He did say the word kill a few times. What did he say? Oh, that's when he was talking about getting Judge Kavanaugh through the Senate confirmation process and into the U.S. Supreme Court. He said, I was fighting for him. No, that's not what he said. He said other senators were telling him, he's killing us. He's killing us. He's killing the party. You got to let him go. Cut him. Cut Kavanaugh. Cut him. Let him go. He's killing us. And he said, not going to do that. He also said this. He also said, everyone here will be soon marching over to the Capitol building peacefully and patriotically to make your voices heard. Make your voices heard, not your guns, not your flags, not your fists, your voices. And he said peacefully and patriotically. All right. So that's just a quick recap of the transcript. Back to Trump's memo. Democrat members of the House drafted the article of impeachment before the investigation into the riot had even started. So this is where he's making a little bit of a due process argument, basically that they crammed this thing through. The members of the Judiciary Committee publicly admitted that they began drafting an article of impeachment moments after the angry extremists breached through the doors. Started right away. Very next day, Speaker Pelosi and Chuck Schumer called on Pence to invoke the 25th Amendment, concluding without even investigating that he incited the insurrection, and he continued to pose an imminent danger. 5 days later, they formally introduced the House resolution. Okay, nobody even knew what was going on that next day. Speaker Pelosi announced the 9 representatives who would serve as the impeachment managers. 1 day later, January 13th, they completed the fastest presidential impeachment inquiry in history, and they adopted it over strong opposition and with zero due process afforded to Trump against the constitutional requirements and centuries of practice. So in about 7 days, it was done. Less than that, really. 5 days. The article of impeachment was already introduced on January 11th. Also not a bad argument, right? If you are formally impeached in a criminal proceeding, typically there's more of an investigation that goes on. We also have paragraph C, the House manager's statement of facts. It outlines a narrative irrelevant to the facts that are alleged in support of the single article of impeachment. So this is, again, where they're making that big argument that basically most of that underlying document, most of the Democrats' memorandum was just irrelevant. They spent nearly 35 of their 77-page trial memorandum rehashing stories written by the media of mischaracterized statements attributed to Trump many months before he even addressed the crowd in the ellipse. Media reports and reporters' opinions are not facts, and most assuredly are not facts that should form the basis of instituting the grave power of impeachment. More significantly, Trump was never charged in the article with claims made in the various reports. So now what they're saying, and we talked about this last week, is 2 things here. One, what Trump and his people are trying to do is really narrow the scope of the argument. And I had some graphics, some slides when we talked about the Democrat memorandum. Specifically, my point there was the original article of impeachment was very broad, but it was also very focused on one particular day. It was January 6th, and then there was another day where they were talking about the phone call that he had with Raffensperger, which is the Georgia Secretary of State, in a settlement conference call. I think they just threw that in there for some reason. I don't think it's particularly relevant, but they were focused on January 6th. They were very upset that that happened. That was the basis. And they specifically, in their article of impeachment, just used a couple quotes from Trump's speech that day. Then in their memo, they really beefed that up. They knew, in my opinion, that they couldn't succeed on a small, narrow claim like that. So the standard for impeachment was very low. Basically, if you said something and something bad happened, that's it. That's the standard, which is why we had fun with the impeachment party and impeached Kamala Harris and all that stuff. Then the memo came out and said, okay, well, now we know we're not going to be successful only focusing on the January 6th commentary, on that speech, on that transcript. So they beefed it way up. They said, okay, now we're going to go back months. We're going to say, all right, this stuff happened. Rudy said this. Sidney said that. Lynn said that. Trump said this on January 5th, 4th, 3rd, all the way back to November 3rd in the election. And they're going to try to bring all of that in and make that the conduct that justifies the impeachment. So what Trump and his team are doing, since they really expanded that scope, is they're trying to narrow this puppy back down. They're trying to say, no, I mean, it's not in the impeachment. It's not in the article of impeachment. You just said in the original article that we covered here, that's like 4 pages, 5 pages really, once you get past the header and all that stuff, they're saying, no, you're talking about all sorts of other things that were not in the original article of impeachment. You can't do that, right? That's like charging somebody with a crime, and then the day before trial or a week before trial, you say, oh yeah, we're also going to bring in all of this other evidence. We're going to charge you with that crime and this crime and that crime and that conduct and that evidence, and it's all bad, right? A defense attorney would have a field day about that. No, we haven't had time to prepare. We haven't cross-examined any of those people. That's not in the original article. And so what they're saying here is that basically, all of this stuff was way outside the scope, and it's not even relevant to the underlying complaint, which is that on January 6th, he said something scary that caused the insurrection. Paragraph 1, law enforcement had reports of a potential attack on the Capitol several days before President Trump's speech. And we've talked about this a lot. Despite going to great lengths to include irrelevant information regarding the comments dating back to August 2020 and various postings on social media, House managers are silent on one very chilling fact. The FBI has confirmed that the breach at the Capitol was planned several days in advance of the rally and therefore had nothing to do with the speech on the 6th. According to investigative reports that were released after January 6th, quote, the Capitol Police, the NYPD, the FBI all had prior warning there was going to be an attack on the Capitol. Embarrassingly enough, though, even members of the Democratic leadership themselves have admitted on record, albeit subsequent to January 6th, that they believe the riots were pre-planned, with some, including James C. Clyburn, House Democratic whip, going so far as to accuse fellow House members of coordinating and planning the attack in advance as co-conspirators. The problem with that claim, of course, is that while House managers are clearly eager to make the most of this tragedy for their own personal political gain, House leadership simply cannot have it both ways. Either the president incited the riots, like the article claims, the article of impeachment claims, or the riots were pre-planned by a small group of criminals who deserve punishment to the fullest extent of the law. 33 representatives are only now calling for investigations into members across the aisle. Right? So which is it? Was Trump solely responsible? Did he singularly cause this with his reckless, insightful speech? Or was this planned? And if it was planned, then how did Donald Trump cause it on January 6th? Well, the response to that is, well, it was everything else he said. It was all of the other statements going back to August 2020. That's what led to the pre-planning. Then he just sort of triggered it on that particular day, on January 6th. That's their argument. And if that's the argument, then why wasn't all of that included in the original article of impeachment? Because the original article, it sort of loosely touched on it so that he was like irresponsible rhetoric. And then on January 6th, he said these things, which then caused that. So they're now trying to expand that scope so broadly that they can get this stuff in. Here are some of the quotes, or these are the footnotes where this stuff came from. Planned attack that was cited over from Real Clear Politics, another article from Daily Mail, another article from Forbes. Okay, Republican congressman's top 8 admits to being with the mob. Democratic whip James Clyburn says they're going to go get him. Planned attack, and on and on and on. Words matter. And the words of Trump's January 6th speech speak for themselves. Did not direct anyone to commit lawless action. The claim that he could be responsible of a small group of criminals who had come to the Capitol of their own armed accord and ready for a fight completely misunderstood him. They were so enamored with him and inspired by his words that they left his speech early and then walked a mile and a half away to imminently do the opposite of what he had just asked for. It's simply absurd. The attack on the Capitol was horrific, period. But as the constitutional professors and experienced practitioners agree, the president didn't mention violence on Wednesday, much less provoke or incite it. Next argument. The Senate lacks the constitutional jurisdiction. Jurisdictional arguments are less interesting. I mean, they're, very pertinent and probably the most legally important, but they're just a little bit more boring than some of the other arguments. And what this does is they address what the powers of impeachment say in the Constitutional says about impeachment at 4 different places. Article 1, Section 2, Clause 5 says the House of Representatives shall choose their speaker and they shall have the sole power of impeachment. Got that part. Article 1, Section 3, Clauses 6 and 7. The Senate has the power to try the impeachments. When sitting for a purpose, oath, or affirmation, the Chief Justice shall preside when the President of the United States is tried. But he's not the president anymore. The Chief Justice is not presiding. No person shall be convicted without 2/3. Judgment in the cases shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor. The party convicted shall nevertheless be liable to other proceedings. Article 2, Section 2. The president shall have the power to grant reprieves and pardons except in impeachment. And Section 4. The president and vice president and all civil officers of the U.S. shall be removed from office on impeachment for high crimes and misdemeanors. So what they're doing in this argument is they're saying this shall word, shall be removed from office on impeachment, is very closely related to the other provisions in the Constitution. In other words, if you cannot execute this, if you cannot remove somebody from office, then impeachment is without effect, because they're already removed from office. I think it talks about it here a little bit later, so let me not jump the gun on this. They talk about a bill of attainder. The impeachment of a former president, a private citizen, constitutes an illegal bill of attainder. The impeachment trial would be nothing less than a trial of a private citizen by a legislative body. That's not allowed under the Constitution. Article 1, Section 9 says no bill of attainder shall be passed. They do not want Congress to put people on trial in this country. Okay, England did that back during the founding days, and it was a big problem. They want you to go through the justice system. That's why we have a judiciary, a justice branch. The bill of attainder, as this clause is known, prohibits Congress from enacting a law that legislatively determines guilt and inflicts punishment upon an identifiable individual without provisions and protections of a judicial trial. It's a legislative act which inflicts punishment without a trial. The distinguishing characteristics between a bill of attainder is the substitution of the legislative determination of guilt and the finding from a judicial finding. When the Senate undertakes an impeachment trial of a private citizen, it is acting as a judge and jury rather than a legislative body. This is exactly the type of situation that the bill of attainder provision in the Constitution was meant to preclude. It's clear that disqualification from holding future office is a kind of punishment that is subject to the constitutional inhibition against the passages of bills of attainder. So they spent a lot of time going into that. You can read those arguments a little bit more fully if you would like. Let me just keep going on some of this jurisdictional stuff so we can get to the free speech stuff. The Constitution only gives the Senate jurisdiction over the president, not the former president of the United States. And here's where they get into that argument. So they say textual support says the founders' use of the word shall means we got to listen to it. Justice Scalia said the same thing, shall be removed from office. He wrote, the word shall can be reasonably understood as mandatory. It ought to be taken that way. The Supreme Court in 2007 said the word shall generally indicates a command that admits no discretion on the part of the person instructed to carry out the directive, according to Black's Law Dictionary and the Supreme Court. The text then is very clear. Conviction at an impeachment trial requires the possibility of removal from office. Without that possibility, there cannot be a trial. The civil law, we hear about the Rule 12b-6 under the Federal Rules of Civil Procedure. It says, failure to state a claim upon which relief can be granted. Failure to state a claim upon which relief can be granted. Kind of a same thing that we heard with a lot of the underlying election litigation. When Donald Trump was suing in the various courts around the country back in the days after the election, a lot of the courts were saying very similar things. They were saying, listen, it's already been certified. We can't reverse that. It's done. Okay, we have no relief that we can grant you. We know you want us to throw out 7 million votes, but they've already been counted and certified. So we cannot grant you that relief. Therefore, we have to dismiss your claim. I know you're mad. I know you got all this evidence. I know you're suing us, and I know you've got a lot of good things to talk about, but we legally cannot grant you what you're asking for. Therefore, we got to dismiss your underlying complaint. We can't hash this stuff out in courts and then just say, well, boy, it would be nice if we could do something about this, wouldn't it? But you can't. So they're not going to let you go through it all unless they can help. Same concept here, right? If the Constitution is saying that the relief is removal from office, he's already removed, what are we talking about leading up to that removal? They can't grant relief. It's already been granted. You guys already got what you wanted. He's not in office anymore. So they're making that argument as well. House managers, this is where they're also talking about former presidents. Hadn't heard this argument before, but this is a good argument. House managers have no authority to legally redefine former presidents as presidents. So they're two distinct concepts. Would they accept a former president conducting foreign policy on behalf of the U.S.? No. Right? Because he's not the president. Would they be content to have a former president nominate a justice for a vacancy on the Supreme Court? Of course not. They're not the president. Former president is actually a term of art with legal ramifications. It's evidenced by the Former Presidents Acts. Title 3 U.S. Code 102, which states, as used in this section, the term former president means a person who held the office of the presidency and does not currently hold such office, right? It's a former president. It has legal meanings. Just like when you read it in the Constitution and it says the president, it means the president, not a former president. And I like how they reference back to the Former Presidents Act, which defines that under the U.S. Code. but they're moving forward anyways. They also go through this long history of precedents, which I'm not going to spend a lot of time on. Historical precedents, the failed attempts to impeach Senator William Blount and the Secretary of War William Belknap. The House managers suggest there is congressional precedent for impeaching a former president because they refer to a former senator and a former Secretary of War. They do not provide any binding precedential authority for impeaching a former president. And that's kind of what I was thinking as well. I think the Constitution specifically says president in there with a capital P. That means we're talking about the president. So I understand what the Democrats were doing, and we went through some of this in their memorandum, but they were saying that we can sort of analogize. We can use what happened with William Belknap and William Blount, and we can make the same arguments here. But the Constitution doesn't say anything specifically about the Secretary of War or a senator. It talks about civil officers, the vice president, and the president. So, okay, it can be a little bit instructive. It can be persuasive. We can say, all right, well, they did it that way with the Secretary of War, so maybe we're going to do it this way now. But it's not binding. Just because they did it that way doesn't mean we got to do it that way. It's still open for interpretation, open to interpretation. All right, let's go on to the next paragraph. More recent impeachment proceedings. So, like I said, I didn't spend a lot of time on the historical stuff, but more recent proceedings. This is a good example from what happened with Nixon. Congress has acknowledged and exercised its duty to not impeach when the official is no longer in office. In the case involving Nixon, Congress decided not to impeach because he resigned. As a practical matter, the resignation of an official about to be impeached generally puts an end to impeachment proceedings because the primary objective, removal from office, has been accomplished. And this is referencing House rules, I believe. In May 1974, House Judiciary Committee began informal impeachment hearings against Nixon in regard to the Watergate scandal. A couple months later, July, the House Judiciary Committee approved 3 articles of impeachment and then reported them to the House for full consideration. Knowing that he was, in fact, about to be impeached in the House and convicted in the Senate, Nixon resigned. The House officially ended the impeachment process against him on August 20th by accepting the committee's report, but deciding not to further advance the impeachment proceedings. So you've got some precedent in that one, right? He's not in office anymore. They terminated it. Now, I think that was in his second term. I could be wrong about that. So he might have been precluded from running again because he'd already hit the cap, the 2-term cap. And so maybe back then in the 70s, they were thinking, well, he's not going to run again. Kind of a lame duck anyways. Who cares? We're not going to move this thing forward. A little bit different here. Right here, Donald Trump only served 1 term. So theoretically, he could run again. And that's, it sounds like, what they're so up in arms about. All right, next one. Paragraph B. Congress's power to impose penalties upon conviction of impeachment is limited to removal and not or disqualification. So this is kind of a clever headline. They're using the same type of language that you would see in the Constitution in the headline here. Limited to removal, comma, and not or disqualification. Same language you see in the Constitution. Constitution grants Congress only the power to remove a person's right to run for office when it is part of a process of removal. So you can stop them from running again if it's part of removal. But if they're already removed, then you don't get to move forward with that second contingency. Article 2, Section 4 says the only purpose of an impeachment is whether, quote, the president, the vice president, and all civil officers shall be removed from office. The only purpose of impeachment is to remove the president, vice president, and civil officers from office. When a president is no longer in office, the objective of the impeachment ceases. So it's one after the other. You've got one domino going into the next domino. Impeachment, conviction, then removal. Can impeach and remove, removal, then prevention from running again. I got that mixed up. So you cannot prevent from running again without first removing. That's what their argument is. In addition, at any given moment in time, the majority could threaten to impeach former office holders of the minority party unless support is forthcoming on a particular appropriations or bill. In other words, the ongoing threat of impeachment might distort lawmaking and as a functional matter might interfere with the balance of powers otherwise prescribed in the Constitution. This is a dangerous, slippery slope the Senate should be careful to avoid. Were it otherwise, a future House could impeach former Vice President Biden for his obstruction of justice in setting up the Russia hoax in 2016. While he could not be removed from the vice presidency because his term ended, he could be barred from holding future office. The same flawed logic the House managers advance could apply to former Secretary of State Clinton for her violations of 18 U.S. Code 793. Impeachment cannot and should not be allowed to devolve into a political weapon. And I think this is probably the biggest reason. I think this is probably a big reason why, even though many Democrats are going to vote in favor of this, I think that if this were really a place where they could all vote, all of the senators, maybe I'm just too cynical here, but I don't think that they want this type of precedent set. If any senator could be impeached and prevented from running from office again in the future, which is what this precedent would set. If Donald Trump is convicted, even though he's not in office anymore, and he's precluded from running again, they could do that for any politician in this country. And the political pendulum swings both ways. Okay, right now it might feel very good for the Democrats because it's Trump on the ropes. But if that balance shifts, now you can have any party just impeaching prior people for virtually anything because the standard is so low. And senators don't want that to happen. Are you kidding me? They've all got their eyes on the presidency or governorship or whatever it is. Ambassadorship, something like that, right? They all want something else. Secretary of State. So if they have this threat of impeachment hanging over their heads their entirety of their careers, even if they're not in office, that's a big concern for them. And I think that alone might be the reason why they don't support a conviction here. They want to protect their own entity. They want to protect themselves. And this would give another tool to the political parties to go in there and interfere with it. All right, the Senate does not have the power to try a former president and should dismiss the article of impeachment. Any other outcome would do profound and lasting damage to the institution of the presidency. In this political climate, we've seen the statutes and monuments of former presidents attacked because of their values of the times were not in line with supposed modern sensibilities. If the impeachment of a former president is allowed to go forward, we could expect dozens more to follow from potentially both sides of the aisle, depending on which party happens to be in the majority. And that's exactly right. I mean, we have templates now available for that. You can just download an impeachment template. We got 2 of them now. Maybe there's going to be more to come. Everybody can be impeached for anything, and it's just indefinite. They don't want to do that. Just like they're not going to put term limits on themselves, right? Just why they always come in and say, no, we're going to we're going to run for 2 terms. They run for 3. They all want as much power as possible. This precedent would limit their ability to do it. Right now, it probably feels good for a lot of them. Yeah, we're going to go get Trump, but the pendulum swings the other way, as Mitch McConnell has shown when it comes to the filibuster. Is that what they really want? I don't think so. The article of impeachment violates Trump's First Amendment rights. So this is kind of the last main section that I wanted to cover. First Amendment rights. The Democrats, if you recall, they said that you don't really have First Amendment rights when you are the president and you're subject to an impeachment proceeding, right? First Amendments, according to them, are not an excuse to go out there and say dangerous things. You can't lean on that to protect yourself. Let's see what their response is. Aside from the fact that it does not constitute a crime, let alone a high crime or misdemeanor, the speech fell within normal political speech that is protected by the First Amendment. To try him for that would do a grave injustice to the freedom of speech in this country. Perhaps in realization that his speech was clearly within the bounds, House managers attempted to erect artificial roadblocks. Senator Schumer knows a little bit about that, to prevent the Senate from even considering First Amendment principles in these impeachment proceedings. These efforts, as fully discussed below, are complete sophistry and should be rejected by the senators who are duty-bound to consider and apply the First Amendment. The Senate cannot disregard the First Amendment jurisprudence. Supreme Court long established free speech jurisprudence. This is, we're going to get into a little bit of legal analysis. This is good stuff. The House Managers Trial Memorandum expressly advocates for the Senate to disregard First Amendment principles, saying, quote, the First Amendment does not apply at all to an impeachment proceeding. We read that. In doing so, they shockingly invite senators to violate their own oaths to uphold the Constitution and the bedrock principle established over 200 years ago that the Supreme Court is the final arbiter of whether congressional acts are consistent with the Constitution. There is no actual precedent for this confounding precept offered in the House manager's brief, but the managers astonishingly cite a few recent internet blogs. And I remember reading that in their memo. They said that basically you don't have free speech if you're a politician, or if you do, it doesn't apply to an impeachment proceeding. Right? And this got me thinking about, okay, well, don't you want your politicians to have free speech? Don't you want them to be able to say things that are, dangerous even? I mean, everything is kind of dangerous to everybody. I mean, think about what politicians say, right? Got to wear your mask, right? That's dangerous for some people. Not everybody, not most people, but for some people it is. Donald Trump was out there talking a lot about China, right? Every time he said something about China. It's kind of dangerous. What if we have World War III because Donald Trump said something that caused China to go ballistic? Right? It's kind of dangerous, but we want to hear from that. We want to hear these people tell us what's up. Everything's dangerous. All right, let's go on. Paragraph 2. We have Mr. Trump, as an elected official, has First Amendment rights to freely engage in political speech. Another roadblock they used is the legally unsupported idea that because he's an elected official and the president, he has fewer rights under the First Amendment than everyone else. This is sophistry. The opposite is true. The Supreme Court has long held that the First Amendment right to freedom of speech protects elected officials like Mr. Trump. The House manager's argument, to the contrary, ignores well-established precedent, erodes the constitutional principles guiding this august body. In fact, the argument of the House manager so materially omits the relevant constitutional precepts that an extended discussion becomes both necessary and warranted, especially in light of what they submitted. The speech was fully protected. Protected speech, the House has characterized as, quote, incitement of insurrection. We're going to get into a test here in a minute. The attempt of the House to transmute the speech, the core free speech under the First Amendment, into an impeachable offense cannot be supported. Convicting him would violate the Constitution, the same Constitution that they were swearing to uphold. Even political speech that may incite, this is where we get into the incitement language. We're going to look at the Brandenburg Test. Even political speech that may incite unlawful conduct is protected from the reach of governmental punishment. Even speech that may, you understand that? May incite unlawful conduct is protected. Indeed, quote, every idea is an incitement. If speech may be suppressed whenever it, quote, might inspire someone to act unlawfully, then there is no limit to the state's censorial power. The government may not prohibit speech because it increases the chance an unlawful act will be committed at, quote, some indefinite future time. The government may only suppress speech for advocating the use of force or a violation of law if, quote, such advocacy is directed at inciting or producing imminent lawless action and is likely to incite or produce such action. And this is a legal standard that we're going to break down. This is called the Brandenburg standard. It's incitement if it's directed towards inciting or producing. That's a first one. So it's got to be directed. Then it's got to produce imminent lawless action. So you got to figure out what that is. What does imminent mean? Right? What is lawless? And we have an and here. It is likely to incite or produce such action. So it's designed, it's directed at that, and it's also likely to produce such action. So let's see how this test is applied. And it comes from this Supreme Court case called Brandenburg versus Ohio. Supreme Court formed a test that placed even speech inciting illegal conduct within the protection of the First Amendment. This is why I'm so aggressive in my belief in free speech. In that case, a leader of the Ku Klux Klan was convicted under an Ohio criminal law statute. Evidence of his incitement was a film at a Klan rally. It included racist and anti-Semitic speech, the burning of large wooden cross, several items that appeared in the film, including a number of firearms. Sounds pretty dangerous. The leader of the protest claimed, We're not a revengent organization, but if our president, our Congress, our Supreme Court continues to suppress the white Caucasian race, it's possible that there might be some revenge taken. We are marching on Congress July the 4th, 400,000 strong. So it sounds like he's trying to incite violence, right? The Democrats would say that is dangerous speech. Probably ban him off Twitter, kick them all off the place. Reprehensible speech, reprehensible organization. I'm not defending the Ku Klux Klan at all. But this is the type of speech that the Supreme Court held, said the constitutional guarantees of free speech and free press do not permit the government to forbid or prescribe advocacy of the use of force or of law violation except where such advocacy is directed to inciting or producing imminent lawless action and is likely to incite or produce such action. That's the Brandenburg Test. The court explained that, quote, the mere abstract teaching of the moral propriety or even moral necessity for a resort to force and violence is not the same as preparing a group for violent action and steeling it to such action. Okay, so in this video, there's this racist white guy who's out there saying, we're going to storm the Capitol. If they don't listen to us, we're going to take revenge. There might be some revenge taken with videos of guns, burning crosses, most reprehensible organization ever. And that's okay. That's protected speech. Okay, free speech means the disgusting, awful, dangerous speech. That's what needs protecting. You don't need to protect polite speech. Oh, hey, Mr. Gruller. Oh, hi, Miss Smith. And hi, that's all. That's fine. Nobody cares about that. Don't have to protect that stuff. Don't have to protect the speech that is just vanilla, benign, boring, irrelevant, bland speech. It's there to protect awful speech, awful things, bad ideas, even dangerous ideas. That's what it's there for. So the Ku Klux Klan, they're protected. And we've gone through the Brandenburg Test before. Right? We want that type of speech out there, I think, personally. So we can see it. Identify these people. Beat their ideas back. Not throw them in jail. They'll do something that's worth throwing in jail. But we want people to be able to speak. The Brandenburg Test is a high standard. Supreme Court has said that. It's got to meet that level. It's got to actually cause something or be likely to do that. The events, and this goes on, the events of January 6th, the Capitol were terrible. The loss of life, let alone a member of the Capitol Police, is a tragedy. But impeaching a former president is not the answer. The Senate should vote to clear Mr. Trump of any wrongdoing. The hostile reaction of the crowd does not transform protected speech into incitement. What matters is the objective meaning of the words. Courts do not deem speech unprotected based on how it could possibly be contorted or misunderstood by an unreasonable listener. Rather, they engage in an objective inquiry to determine how a reasonable person would understand the words. Otherwise, speakers at public events would be put at the mercy of the unhinged reactions of their most unreasonable audience members. That is exactly what happened on January 6th, but the Senate, composed of reasonable and erudite members, can take a few minutes and read the speech themselves. So what they're saying is, what would a reasonable person do in that situation? Would a reasonable person have heard that speech and said, oh, I know what he means. Let's go storm the Capitol? The answer is no. A reasonable person listening to that speech would go, okay, that's a pretty typical Trump speech. And if the standard is different, if you just say it's whatever anybody does after they've heard you, do you want to be on the hook for that? If you go give a speech and somebody goes and kills themselves, are you responsible for that? If you said something and something bad happened, that's the Democrats' standard, essentially. Very loose, very low. If we raise that bar and now it's what a reasonable person would do, and we actually look at the words, you're going to have bad speech in there. You're going to have disgusting, awful speech like the Ku Klux Klan and others. I'm not endorsing that speech at all, but it's protected because free speech is that important. All right. And finishing up the Brandenburg Test, the Supreme Court erected an extremely high bar to proving incitement. Right? I just said that. Test requires proof the speech explicitly or implicitly encouraged the use of violence or lawless action. So this is another case where they're actually fleshing this test out a little bit more. And they give us these 3 prongs. This footnote comes from a different case. The speech explicitly or implicitly encouraged the use of violence or lawless action. Did not happen in my reading of Trump's speech. The speaker intends. So the person giving the speech intends this speech will result in the use of violence or lawless action. I don't think you could say that at all. And number 3, the imminent use of violence is the likely result of his speech. I think you could debate that one. Right? Other people would say, yeah, absolutely. He knew what he was doing. It was likely to happen. I disagree, right? The allegations against Trump unquestionably fail as a matter of law. Advocacy for the use of force, lawless behavior, intent, imminence, they're all absent. The doctrine of incitement absolutely has no application to this case. Paragraph 4. The figurative use of the words fighting has been used by many, many people, and they go through some examples here. It's incredible, they say, that House Democratic leadership is feigning horror at the president's choice of words. Other people have done the same thing. For example, in 2018, Nancy Pelosi held her weekly press conference at the Capitol Visitor Center. She referenced the policy she disagreed with. The most powerful Democrat in the country said, "I just don't know why there aren't uprisings all over the country. Maybe there will be." Was she advocating violence? Was she sending a silent dog whistle to radical protesters? Should she be held accountable for her extremist rhetoric and removed from office? And they go through other examples. They have Maxine Waters in there. We've all heard her. You get in their faces, right? Ayanna Pressley was in there. There's some other ones in there. So you can go read that if you want to. There are a couple of procedural issues that we're going to just kind of fly right through. The House afforded President Trump no due process of law. They spent some time on that. The article is structurally deficient. We've already talked about that. So structurally deficient, meaning that the issues are commingled with one another. They're saying that there are several different claims in there. The Raffensperger claim. They've also got the claim that you're not going to have a country anymore if you don't fight like hell. They also have another one saying something about fighting. I can't remember the quote off the top of my head, but it's all commingled. So now the senators don't know what to vote for. It's either all or nothing. And if in that situation, that is a deficient complaint. You want to be able to separate things out. And I think last week we used the candy bar analogy, where we're saying, all right, well, the Snickers, the Twix, and the M&Ms. If you just lump them all into each other and you only say to the jury, hey, you can only vote on all this stuff. And you say, well, I think he stole the Snickers, but not the M&Ms. They say, well, that's too bad. Did he steal it or not? You go, well, I can't really make a decision on it. You can't split it. That's why they're saying it's structurally deficient. The article fails to state an impeachable offense. The president didn't commit incitement or any other crime. So if you're going to be charged with a high crime or misdemeanor, can we define what the crime is? If you're saying it's incitement, we already went through the Brandenburg Test, which would lead to criminality. If you met the test, he doesn't meet the test. What other crimes do you have? I think that's originally why they threw in the settlement conference with Brad Raffensperger, but I don't think that's a crime either. I think it was a settlement conference where you settle things and talk about votes. All right, let's look at the conclusion, and then we're going to get into some news. And we have an article of impeachment we have to go through, a new one that I wrote. Conclusion, the article of impeachment presented in the House is unconstitutional for a variety of reasons. Taken together, they demonstrate conclusively that indulging House Democrats' hunger for this political theater is a danger to our republic democracy, maybe to our democratic republic, and the rights that we hold dear. Reasons for dismissals include Senate lacks jurisdiction. Not in office anymore. You got to be in office to be removed. Paragraph 2, the Senate lacks jurisdiction because he holds no public office from which he can be removed. The articles of impeachment are moot and non-justiciable. Should the Senate act on the article of impeachment, it violates the Bill of Attainder clause of the U.S. Constitution. The article of impeachment allegations are self-evidently wrong. Read the transcript, read the actual speech. The allegations fail to meet constitutional standard for any crime, let alone an impeachable offense. Paragraph 5, the House of Representatives deprived him of due process by rushing it through. There were no meaningful committee reviews, no investigations, no full and fair consideration of the evidence. There was no full and fair discussion allowing the 45th president's positions to be heard. No exigent circumstances under the laws were present, requiring them to rush through, because they rushed through it and then they held the article for another 12 days. It was just sitting there. Paragraph 6, Violates the president's right to free speech. 7, the article is constitutionally flawed. Multiple instances of allegedly impeachable conduct in a single article. Should have been broken up. The Senate should dismiss these charges and acquit the president. This is clearly not what the framers wanted. All right, so that is it for Trump's defense memo.